Hi everyone, welcome to Impact Academy. I'm Yashash Vichintara. So today let us continue with polity questions. Last class we have seen till 45. Let us continue from 46. So consider the following with reference to national emergency. Okay. So before answering the question, let us quickly look at different types of emergencies. Okay. So we have national emergency, president's rule, and financial emergency. And even the articles are important. Okay. National emergency is Article 352. Let me make it big. So national emergency is 352, president rule is 356, and financial emergency 360. Financial emergency has never been what you say applied on India, okay, any part of India. So anyway, so what is national emergency? Article 352 says external aggression or armed rebellion. Now this word armed rebellion has been added in the 44th amendment. Okay, before that it was just internal struggle. Okay, and it was misused in 1975, right? So national emergency was what you say established. So it was changed in the 44th Amendment to armed rebellion. So there has to be external aggression, so some form of war from outside or within the country also there has to be armed rebellion. So it's not just like people coming onto the street for protest and you declare national emergency. It doesn't happen like that because once you declare national emergency, a lot of the fundamental rights and all those things they get changed. Okay, they become, most of them become ineffective, and you lose right to go to court and all those things. So let us look at it. So president's rule is also known as state emergency, and financial emergency. President to proclaim financial emergency if he is satisfied that a situation has arisen. Okay, so president's rule is almost called as state emergency because usually it is applied in the states. Now, national emergency, 42nd Amendment of Act of 1976, President can limit operation of national emergency to particular area. Okay, because national emergency in 1975 due to internal disturbance. So now it is not just internal disturbance. Internal disturbance is not enough. You need to have external aggression or armed rebellion. The president can proclaim only after receiving a written recommendation from the cabinet. Okay, he has to receive written recommendation. And proclamation of national emergency is also brought under judicial review. Starting from the Minerva Mills case, 44th Amendment Act. So you cannot say that it is beyond judicial review or I got a written recommendation from the cabinet, so an emergency has been proclaimed. Now that even the judiciary can go into the case and see whether it is appropriate or has there been any misuse. Because judicial review is the one of the basic structure of the constitution. And approval must be approved by both houses within 1 month from date of issue. So once that national emergency bill is brought in, it must be approved by both houses within 1 month. If approved, it continues for 6 months and can be extended to infinite with the approval of every 6 months. So all these are very very important. These are some of the questions frequently asked. Okay. So this periodic parliamentary approval is added in the 44th Amendment Act. Okay, so within 1 month it has to be approved and it is for 6 months. And it can be approved for every 6 months for infinite period of time. Approval for continues by continuity by either house by either houses by special majority. Okay, so either house, so either Lok Sabha or Rajya Sabha by special majority, not simple majority. Okay, special majority means what do you say? Simple majority, special majority, and special majority with ratification of half of the states. That is one thing. So special majority is more than what is a two-third. Okay, two-third of the number of people present and voting, and also more than 50% of the what is a more than 50% of the number of seats in that particular house. Okay, more than 50%. So if it is 545, it has to be more than half of that. Okay, 50%, more than 50%, and two-third of the majority of the attendance of the house. Because there can be many members of the house who are not attending that particular session. Okay, who are absent or due to some other work, they are not there. So out of those people present and voting, it is two-third and 50% of the total. What is the total number of the house? So president, how it can be revoked? President must revoke if Lok Sabha 1/10 of the total members of the Lok Sabha give written notice to Speaker. Okay, so if 1/10 of the total Lok Sabha gives written notice to Speaker, then President will revoke it. Revocation by simple majority. So while passing, you need special majority. While revoking, you need simple majority because it is revoking. Like you are, because the danger is over, you are just revoking. Simple. So effect on center-state relations. Center extends its executive power to state, giving directions to the states on any matter. State government is not suspended, but complete control of center. And legislative. Parliament makes laws on state list. However, legislative power of state is not suspended. Laws of Parliament inoperative 6 months become inoperative 6 months after the emergency ceased. President can issue ordinance on state subjects. Okay. Financial. President can modify, reduce, or cancel or distribution of revenues of states. Such order, President has to be laid before the Parliament. Okay. So all these things can be done during the emergency. Effect on Lok Sabha and State Assembly. Lok Sabha may be extended for 1 year at a time. Okay, Lok Sabha can be extended for 1 year at a time. Extension cannot continue beyond 6 months after emergency. So after emergency cease to exist, only 6 months it can continue. And Parliament may extend tenure of State Assembly. Effect on fundamental rights. So Article 358 and 359 effects on fundamental rights during national emergency. So Article 358 is saying it automatically suspends 6 fundamental rights. Okay, only of fundamental right 19 when national emergency is based on external aggression. So fundamental right 19 is basically speech and expression, movement, assembly, association, okay, place of residence, all those things. So during national emergency, you are not allowed to freely free speech and expression or movement, association, all those things are temporarily suspended. It can be suspended for entire duration of emergency and extended and entire country. So that is 358. So 359, suspension of other fundamental rights except fundamental right 2021. So this is important. So even during national emergency also, 21 is right to life and liberty, right? Right to life and liberty, and fundamental right 20 will be, what is that? Fundamental right 20 will be usually something around protection against detention or arrest. Let us quickly look at it. Fundamental. Okay, 20 is protection in respect of conviction for offences. Okay, so Article 19, right? Fundamental right 19 is suspended. 2021 will not be suspended. Protection, even if there is a national emergency, there has to be protection of life and personal liberty, and protection in respect of conviction for offences. Okay, 22 is detention. So 20 is conviction for offences. So just because there is a what is a national emergency, you cannot arrest anyone just like that. There has to be proper grounds. So 20 and 21 is a suspension of other fundamental rights except 2021. Suspends fundamental right at both cases, armed rebellion or external aggression. President may specify duration, and the suspension of fundamental right may be applied to entire country. So 44th Amendment says that there is automatic suspension of fundamental right 19. Okay, that is speech, assembly, and all these things. It is here, right? Okay, speech, association, assembly, movement, residence, profession. So all those things are automatically suspended. And automatic suspension of okay, that's one. Article 359, President suspends right to seek remedy except for 2021. So Article 32 is also partially suspended. Only 2021, that is right to protection against arrest. Okay, and life and liberty. Only those two are there. So all these things are very important. Okay, this 6 months. It can be extended for 6 months. All those things. Okay, and 1 year. Lok Sabha can be extended by 1 year. So that is national emergency. So let us look at the question. Question is on national emergency, right? So consider the following with reference to national emergency. Its proclamation must be approved by both houses of parliament within 2 months from the date of its issue. Okay, so that is wrong, right? What we have seen just now, within 1 month. So 2 months is wrong. It can be extended maximum up to a period of 3 years. So that is also wrong, right? Period of 3 years also we have seen it can be extended up to 6 months at a time, right? And infinite times. Okay, so that is also wrong. Every resolution approving the proclamation of emergency must be passed by either House of Parliament by special majority. So that is true. Every resolution that is approving the proclamation of emergency must be passed by either of House. We've seen. We are not talking about what you say approving the every resolution approving the proclamation of emergency must be passed by either House of Parliament. So is it either House or both the houses? So we're not talking about just extension, right? Approval is 1 month. Okay, it must see approval. It must be approved by both houses within 1 month from the date of issue. Okay, and approval for continuation by either house with special majority. So what is being asked in the question? Every resolution approving the proclamation of emergency. So this is also wrong. It is not proclamation. Proclamation of emergency must be by both the houses, right? That's what I said, right? Um, must be approved within 1 month and can be extended to infinite with approval of every 6 months. Approval for continuation is by either of the houses by special majority. But if the president can proclaim only after receiving written recommendation, that proclamation of national emergency brought under judicial. Okay, all that is fine. And what is this? Okay, so approval if approved continues for 6 months, the approval of every approval for continuation by either house of by special majority. Just so approval is not okay. Approval must be approved by both houses within 1 month from the date of issue, and this is for continuation only, right? Okay, so that much we are clear. So in this particular case, every resolution approving the proclamation of emergency. So if you look at here, every resolution, so he is indirectly talking about continuation only. That is why there is a confusion. So every resolution approving that means first time see its proclamation must be approved by both the houses within 2 months. So this is correct, right? Its proclamation must be approved by both the houses. That much is correct. Within 2 months is wrong. So this is wrong. Okay. Here every resolution means subsequent resolution, not the first one. The first one both houses, but subsequent resolution must be approved by either house of parliament by special majority. So this is correct. Okay, this is not the first time when you are giving when you are proclaiming emergency. Every resolution from that. Okay, first time it is by two houses within 1 month. It can be extended maximum up to a period of 6 months. And every resolution approving the proclamation, every further resolution must be passed by either house of parliament by special majority. So only this one is correct. Yeah. Okay. Consider the following statements. Article 33 provides for restrictions on fundamental rights while martial law is in force in any area within the territory of India. So any law made under Article 33 by Parliament can be challenged in any court on the ground of contravention of any of the fundamental rights. So okay. So which of the following is correct? It's neither one or two. So let us see what is Article 33. So Article 33 is saying power of Parliament to modify the rights conferred by this part in their application to forces. So 34 is the restriction on rights conferred by this part, basically the fundamental rights, while martial law is in force. Okay, and 35 is legislation to give effect to the provisions of this part. Anyway, martial law is 34 and 33 is application to forces. Maybe it is armed forces or police force, etc. So that application to forces is 33. So if you go back to the question, Article 33 provides for restrictions on fundamental rights. Okay, while martial law is in force, this is wrong. So if martial law, we're talking about martial law, then it is Article 34. So this is wrong. Any law made under 33 by Parliament can be challenged in any court on the ground of contravention. This is also wrong. Okay, if it is under 33, it cannot be challenged. So you cannot go You cannot, I mean, anyone in the army cannot say that I have my right to speech and I will speak about all the important army bases, okay, important army codes, everything. No. So when you're in the armed forces or when you're in the police, yours right, some of your rights, fundamental rights are curtailed for national security. So it cannot be challenged in any court. Okay. If you are in the part of the forces, your rights are curtailed. So which of the following features of federalism are not included in the Indian Constitution? So bicameralism is there, right? We have a upper house and we have lower house. We have Lok Sabha, we have Rajya Sabha. Here also we have assembly and council. Written constitution, ours is the written constitution and the lengthiest constitution. States having the right to secede. So our Indian federal system is defined as a indestructible union of destructible states. That means the states can vary. Okay, Andhra Pradesh can become Telangana and Andhra, and Uttar Pradesh can become Uttarakhand, and the boundaries can change, the area can reduce. So states are not indestructible; they can be destructed, but the union is indestructible. So states don't have the right to secede, and that is Article 3, right? The formation of the Indian Federation is a result of agreement by the states. So that is the example of United States. In the United States, the formation of the United States is a result of agreement. So 3 and 4 are clearly wrong. Easy question. Okay. So which one of the following statements is correct with reference to Indian citizenship? All citizens have been granted equal rights, but all citizens cannot exercise them equally. Okay. Citizenship is listed in the concurrent list. No, it is in the central list. Detailed provisions of citizenship are mentioned in Part 3 of the Indian Constitution, which is wrong, right? Part 3 is fundamental rights. So, citizens of India owe their allegiance both to the union and the states. No, citizens of India owe their allegiance to the center, the union, basically the country. There is no division as a union, states, etc. So, option one is that all citizens have been granted equal rights, but all citizens cannot exercise them equally. Okay, that is true. For various reasons, all citizens cannot exercise them equally, but they have been granted equal rights. So consider the following statements with reference to the fundamental rights of the Indian Constitution. Individuals can seek enforcement of the freedom of speech not only against the government but also against the other citizens. Okay, so freedom of speech is freedom of speech. Whether it is against citizen against the government, that is different. It is a freedom of speech. Rights guaranteed under Article 19 are available both to Indian citizens and foreigners. Okay, that is outright false. We have already seen foreigners have what is a few. I mean, Article 14 is there, but Article 15 is not there. Okay, and this Article 19 is also not there. Only 20, 21 is there, and some religious articles are there. Okay, 23, 24, those 25, 26, all those things are there, but Article 19 is not available. So foreigners cannot come here and say we have the right to association, so we will form a trade union. No, it is not possible. Okay, they don't have right to speech, expression, right to assembly, profession, residence, all those things. Okay, they don't have those rights. The president can proclaim a national emergency only after receiving a written recommendation from the cabinet, which is true. We have seen just now. The president must revoke a national emergency if Rajya Sabha passes a resolution disapproving its continuation. Okay, so we are talking about revoke, right? We just now have seen revocation. President must revoke if Lok Sabha, okay, 1/10 of the total members of the Lok Sabha give written notice to the Speaker, not Rajya Sabha. And revocation is by simple majority, and it has to be Lok Sabha, not Rajya Sabha. So here, what is saying? President must revoke if it is passed by Rajya Sabha, which is wrong. So which is incorrect? Two. Two is only incorrect. The term state for the purpose of Part 4, Directive Principles of State Policy, okay, of the Constitution includes which of the following? Okay, central government, state means everything. Central government, state government, local government, public authorities. Okay, all these come into the even these public sector bodies. Okay, all these steel plants, ONGCs, BHPs, all these things come under state definition of state for purpose of Part 4. So D is the right option. Consider the following statements with reference to the Indian Constitution. Writs in the Indian Constitution are borrowed from the American Constitution. No. Okay, we'll look into if the High Court cannot refuse to exercise its jurisdiction. Actually, the High Court can. Okay, the High Court can refuse to exercise its jurisdiction. We'll look into that. The articles also, article numbers we'll see. A quo warranto is issued on the grounds of excess of jurisdiction, lack of jurisdiction, or error of law. Okay, so let us look at American Constitution, what we have borrowed. So, if you look at this American Constitution, okay, from the US Constitution, we have borrowed fundamental rights, independence of judiciary, judicial review, impeachment of president, removal of Supreme Court and High Court judges, and post of vice president. So this prerogative bits we have taken from British. Okay, we have taken writ jurisdiction from British, right? And these are the other important things. Okay, so that is so from the US we have taken these things, and writ jurisdiction is from the British. So let's go back to the question. What is saying is writs in the Indian Constitution are borrowed from the American Constitution, which is wrong. We have borrowed from the English law. Okay, they are also called as prerogative writs. Next, the High Court cannot refuse to exercise its jurisdiction. So, when we talk about the writs of Supreme Court, it is Article 32, right? Similarly, for the High Court, it is Article 226. Very important. So, Article 226 is writ jurisdiction of High Court. Okay, and High Court may also refuse to exercise the writ jurisdiction. Okay, the exercise of the jurisdiction is discretionary in the case of High Court, and uh, I mean, the Supreme Court, I cannot what is a refuse to exercise the jurisdiction, but High Court can refuse. Okay, on the basis like based on a special occasion or some circumstance, it can refuse. So this is also wrong. So pure warranto is issued on the grounds of excess of jurisdiction. That is also wrong. So what is pure warranto? So we have several bits, right? Habeas corpus, okay, mandamus, certiorari, prohibition, pure warrant, all those things are very basics, right? So pure warrant is basically it's like asking the legality of a claim of a person to a public office. So someone holds a public office, so you can file a writ of pure warrant is by what authority he has got that public office. So what are the rules? Have the rules been followed? Is he eligible? All those questions. So, for example, if you want to bring someone as the election commissioner, okay, so there are certain qualifications, certain hierarchy, okay, rules, regulations, everything. So, without following all those things, if you bring someone who is what is loyal to you and make them election commissioner, it is not possible like that. So, then you can go for a pure warrant and say uh, with what authority you can claim a public office. Okay, it is not. It is not excess of jurisdiction, lack of jurisdiction, or error of law. That will come as prohibition, right? So none of the above. So consider the following statements with reference to the preamble of Indian Constitution. Preamble is a source of power to the legislature. Preamble is a source of power to the legislature. Okay, so preamble is a prohibition upon the powers of the legislature. So there is nothing like that. The preamble is not exactly source of what is a power to the legislature. It is just what is like a guiding principle, the heart and soul of constitution, etc. Those things. Okay, it's like ID card or some things, many things like that, but it's not exactly a source of power to the legislature. Okay, it does not deal about any rules or regulations for making laws, etc. And preamble is a prohibition upon the powers of. There's not nothing like that. Okay, the preamble is also not a prohibition. Okay, the legislature mostly derives its powers from various provisions of the constitution itself. Okay, we are several things like election commission, for example, it gets its powers from the constitution. Okay, all these constitutional bodies, etc. So there is nothing like preamble is prohibiting the powers of legislature, nothing like that. The preamble reveals the source of the authority of the Indian constitution. So that you can say is correct. Okay, the preamble states that the authority of the constitution is derived from the people of India. Okay, so if you look at the preamble, it says we the people of India. So that is where the source comes from. So preamble is revealing the source of the authority of the Indian Constitution, but it is not a source of power of the legislature. Try to keep that in mind. And preamble is non-justiciable. Yes, it is non-justiciable. Okay, you cannot enforce it in a court of law. But the judiciary will often take the preamble into consideration. If there is any ambiguity regarding any provisions of the constitution, definitely the preamble also will be taken into what is the consideration. So three and four are the correct. I mean, which of the following are correct? Three and four. One or two are wrong. So during the following the consider the following statements with reference to effects of national emergency. State governments are brought under the complete control of the center, though they are not suspended, which is true, right? We have already seen. So they are brought under the complete control of the center, but they are not suspended. Okay, even under normal times when there is an emergency, also center can give executive directions to a state. Okay, on certain specified matters. That is also there. So the center always has the power to give executive directions. The legislative power of a state legislature is suspended and handed over. So it's not like legislative power is suspended; it becomes subject to the overriding power of the parliament. Okay, during a national emergency, parliament becomes empowered to make any laws on any state subject mentioned in the state list. That does not mean that the legislative power of state is suspended. Okay, it is also there, but parliament gets overriding what is say powers. Okay. So, state laws are not suspended. The constitution becomes more like unitary rather than federal. Okay, that's what you need to keep in mind. Next, when a national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal time. So we've already seen, right? It can be extended by 1 year at a time. We've already seen just now. So when the national emergency is in operation, life of Lok Sabha may be extended beyond its normal parliament for 1 year at a time, for any length of time. Okay. However, we already seen this extension cannot continue beyond a period of 6 months. Okay. After the emergency has ceased. Okay. So this fourth one is also correct, right? The president can cancel the transfer of finances from the center to the states. So we will see that executive, legislature, and financial powers also will be in the hands of the center. In the center. Okay. So Supreme Court, which one of the following best describes the differences in jurisdiction of the Supreme Court and that of High Courts with reference to the purpose of issuing writs? So Supreme Court and High Courts, let us look at it. So let us quickly go through Supreme Court and High Court. Okay. So Supreme Court inaugurated 20th Jan 1950, single system of court adopted from GOI Act of 1955. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. 1866, a fourth High Court was established at Allahabad. So Supreme Court replaces British Privy Council in 1950. Okay. Constitution declares Delhi as seat. However, CJI can appoint other places as seats. Parliament cannot curtail jurisdiction of Supreme Court. However, Parliament can extend jurisdiction of Supreme Court. So remember this. It cannot curtail, but it can extend. Supreme Court is custodian of Constitution of India. The Constitution of India provides for a High Court for each state, but the Seventh Amendment Act of 1956 authorized Parliament to establish common High Court. Okay, so under Seventh Amendment Act of 1956, two or more states can have common High Court, like Punjab and Haryana. Okay, so as of 2019, there are 25 High Courts in the country. There is only one Supreme Court and 25 High Courts in the country. Fine. Next. So, 2009, the center notified an increase in the number of Supreme Court judges from 31 to 34, including the Chief Justice of India. So, 34. The judges of Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Court. The other judges are appointed by the President after in consultation with the Chief Justice and such other judges of the Supreme Court and High Court. So basically, President will appoint all the chief justice and also other judges also. So they might ask question like the chief justice is appointed by the president and then the chief justice appoints the other judges. No, the other judges are also appointed by the president. The consultation with the chief justice is obligatory in case of appointment of a judge other than the chief justice. Okay, other for other judges it is obligatory. And here every high court consists of chief justice and such other judges. Okay, constitution does not specify the strength of a high court and leaves it to the discretion of the president. Judges of a high court are appointed by the president. See, high court also president. The chief justice is appointed by the president after consultation with the chief justice of India and governor of the state. So remember this. Okay, in this case he is consulting with the chief justice is appointed after consulting with such judges, Supreme Court of High Court. Here, he is for the appointing the chief justice, he is going to consult with the chief justice of India and governor of the state concerned. So in 2015, Supreme Court declared both 99th Constitutional Amendment as well as the 9JCA Act as unconstitutional and void. The National Judicial Appointments Committee has been voided. So qualification of judges, he should be citizen of India. He should have been a judge of a high court for 5 years. Okay, he should have been a judge of a high court for 5 years. He should have been an advocate of a high court for 10 years. So if it is judge 5, advocate 10, he should be a distinguished jurist in the opinion of the president. Constitution has not prescribed a minimum age for appointment as a judge. Citizen, okay, he should have held a judicial office in the territory for 10 years and he should have been an advocate of a high court. Okay, here also advocate of a high court for 10 years, 10 years. Constitution makes no provision for appointment of distinguished jurist. A high court, so for High Court, there is no concept of distinguished jurist. Okay, only Supreme Court has a concept of distinguished jurist. Both. So in the Supreme Court, before the president, and then what you say here before the governor. Okay, so High Court judges take the oath of affirmation before the governor, but they are appointed by the president. Keep that in mind. So tenure, Constitution has not fixed the tenure of the judge of Supreme Court. He holds office until age of 65. Okay, here it is 62. Here also there is no fixed tenure. He can resign by writing to president. Here, High Court, he can resign by writing to president. Same, he can be removed by the president on the recommendations of the parliament on proven misbehavior and incapacity. So here also recommendation of the parliament. He can be removed by recommendation of the parliament on grounds of misbehavior and incapacity. So removal of judges and this we are talking about tenure. Constitution as for the judge of Supreme Court, judge of High Court. So the Judges Enquiry Act 1968 regulates the procedure. Removal motion signed by 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. Speaker and chairman may admit the motion or refuse to admit it. After the motion is passed by each house of the parliament by special majority. Okay, each house, both houses by special majority, an address is presented to the president for removal. No judge of the Supreme Court has been impeached so far. So if you look at High Court also, judge of High Court can be removed by order of president. Same 100 members, 50 members, and parliament. Okay, the parliament special majority. So it is not state legislature. Okay, in order to remove the High Court judge also, you have to impeachment process should go through the parliament. Same as that for a judge of the Supreme Court. So whether it is High Court or Supreme Court, impeachment process is same. So the president can transfer a judge also. So all these are fine. So original jurisdiction, writ jurisdiction. So there is a lot more. Let us see first the question. So what it's saying. So which of the following best describes the difference in writ jurisdiction of the Supreme Court and that of High Courts? Okay. Supreme Court can issue writs for any purpose. Okay, this is the question. Okay. So Supreme Court, just a minute. Okay. So Supreme Court can issue writs for any purpose, while a High Court can issue them only for enforcing fundamental rights. Okay, there's no such thing, right? Even High Court will issue writs. Okay, for other purpose also. So Supreme Court can issue writs only for the enforcement of fundamental rights, while a High Court can issue them for any other purpose. So this is true. So that is why usually it is said that the jurisdiction, which jurisdiction of High Court is superior to the Supreme Court. Okay, it is more powerful than the Supreme Court. I mean, more wide scope for the High Court. Okay, it can issue for any other purpose also, while Supreme Court can only give for fundamental rights. Supreme Court can issue writs for ordinary legal rights, no fundamental rights only. Supreme Court can refuse, so it cannot refuse. Supreme Court cannot refuse, whereas High Court can refuse. Okay, try to understand that. So High Court can issue for any purpose, Supreme Court only for fundamental rights. So which of the following features of the Indian Constitution elucidates the secular character of our political framework? Okay, so no religious instruction. Okay, no religious instruction in state-managed schools. Okay, which of the following features of Indian Constitution? The secular character. Fine. So no religious instruction in the state-managed schools. Promotion of a UCC. Okay, that's also you can say secular character. Okay, promotion of UCC also. Fine. No compulsion for payment of taxes to religious institutions. Okay, freedom of conscience. So this is already you've seen Article 27, 28, 29, all those things, right? So state shall not deny. I mean, if you see Article 14, state shall not deny any person equality before law or equal protection of law. So 15 also we have seen state shall not discriminate against any citizen on the grounds of religion, and 16 is public employment. And Article 25 is about religion, right? All persons are equally entitled to freedom of conscience, propagation, practice, and all those things. Religion we have seen, right? And Article 26, okay, 25, 26, 27, 28, completely related to religion. No person shall be compelled to pay any tax. Taxes is 27, and 26 is there will every religious denomination or any of its sections shall have the right to manage its religious affairs. So right to manage religious affairs, no need to pay taxes 27, and then no religious instruction shall be provided in any what you say any state managed institution. Okay, so and also the state shall endeavor to secure for all citizens a uniform civil code, which is Article 44, right? So Article 44 talks about the uniform civil code. So all four are correct. All four are for the purpose of what is a secular character of the political framework. So which of the following provisions of the Indian Constitution do not require special majority of the Parliament for their amendments? Okay, so see for the directive principles of state policy. Okay, uh, is talking about which of the following do not require special majority. Okay, so if you look at normal Article 368, there are different types of amendment, right? So the provisions of the Constitution that can be amended by a simple majority of the two houses of the Parliament outside the scope of Article 368 are usually these privileges of the Parliament. Okay, this privilege of the Parliament, its members, committees, and all these things. Okay, these privileges of the Parliament can be amended by a simple majority. Privileges and all these things can be amended by simple majority outside the scope of this state. You don't need a constitutional amendment act also. And if you look at this quorum in Parliament, okay, quorum in Parliament means then how many people? Okay, for in order the session to take place, how many people minimum should be there? So that is also a very simple issue. It does not need a special majority. Okay, and see, abolition of legislative councils is also it does not need a special majority. Okay, and delimitation of constituencies. So delimitation of constituencies is also not it does not require special majority of the parliament. Okay, so directive principles and fundamental rights they require what you say special special majority. Okay, fine. So which one of the following directive principles was added to the 44th Amendment Act? So 44th Amendment Act. Okay, so let us briefly look at what is the 44th Amendment Act. So 44th, okay, 44th Amendment is also very big amendment. It is enacted by the Janata government mainly to nullify some of the other distortions. So 5 years has been made into 6 years by the 42nd Amendment Act that has been what you said restored to the original term of 5 years. Restore the provisions with regard to quorum, that is minimum quorum should be there, and reference all this is fine. Constitutional protection, empower president to send back advice once. Okay, so this is also frequently seen, right? You can send it once, but if the president sends it back and again the cabinet, I mean the parliament sends it back, then the president is it is binding on the president. So powers of Supreme Courts, High Courts made the president declare national emergency only on written recommendation of the cabinet. Very important. Okay, and this right to property has been deleted. All these things. So all these things are 44th Amendment Act of 1978. So which of the following directive principles were added through the 44th Amendment Act? Minimizing inequalities in income and opportunities. Okay, is there anything article? Okay, so just a minute. Let me see. Minimize inequalities in income and opportunities. So that would come under Article 43 somewhere, right? Right. Directive principles of state policy. Let us quickly look at. So somewhere here, right? Living wage. It will come somewhere here. Anyway, so try to remember that. Which of the following directive principles was added through the 44th Amendment Act? Okay, minimizing inequalities in income and opportunities. Okay, so normally if you look at 42nd Amendment Act also, so 42nd Amendment Act also made many changes. Okay, it added four directive principles. So those are Article 39. Okay, to secure opportunities for healthy development of children. 39A. 39A is basically to provide equal justice and provide free legal aid to the poor. Okay, and to take steps to secure participation of workers in the management of industries. That is Article 43. It is a Gandhian principle, right? 43A, specifically Article 43A, and to protect and improve the environment and safeguard the forest. That is 48A. So the safeguarding forests and participation of workers and equal justice, free legal aid to poor, and all these things. Okay, they are under 42nd Amendment Act. So if you look at 44th Amendment Act, it added majorly Article 38. Okay, under Article 38, it requires the state to minimize inequalities in income, okay, facilities and opportunities. And this is Article 38 and 44th Amendment Act. And also 86th Amendment Act is there. Okay, 86th Amendment Act of 2002. It changed the subject matter of 45 and made elementary education fundamental right under 21A. So that is also very important. Okay, so that is also directive principles have been modified. And also there is a 97th Amendment Act. Okay, it added a new directive principle relating to cooperative societies. That is also frequently asked. So all these things 42nd, 44th, 86th, 86th, 97th. Okay, 97th added 43B. So all these are very important. So in this particular case, if you are talking about 44, it is minimize inequalities in income and opportunities. So secure participation of workers in industries is 43A added by 42nd Amendment Act. Protect the environment is also 42nd Amendment Act. Cooperative societies is 97th Amendment Act. Okay, so only this. minimize inequalities in income and opportunities. That is Article 38. So under Article 38, this minimizing inequalities of income and opportunities was added through 44th, and through 44th only one was added. So that is easy to remember, right? All these others are what you say 42nd. Okay, and the cooperative societies is quite recent, right? Cooperative societies is Article 43B added through 97th Amendment Act of 2011. So very recent. And even there, Article 243, there several articles will be added, right? All that is important. Cooperative societies. So, in the context of basic structure doctrine of the Indian Constitution, the basic structure is explicitly mentioned in the Indian Constitution. That is quite wrong. Very clearly, there is nowhere such a thing has been mentioned that there is so and so as basic structure, etc. There is nothing like that. It is just an invention of uh, okay, Supreme Court. You can say the basic structure doctrine was established by the Indian Supreme Court. Yes, that's what I was saying, right? In the case of Keshavananda Bharati versus State of Kerala, that is 1973, one of the landmark judgment, right? And usually, the basic structure doctrine is established by the Indian Supreme Court in the landmark case of Keshavananda Bharati versus State of Kerala, 1973. And just in case, remember, it is a 13-judge bench. Okay, so it's a big bench. Next, basic structure doctrine limits the parliament's power to amend certain core features of the constitution. So that is what is meant by the basic structure, right? That you cannot take away the basics, fundamental, like the secular nature, okay, supremacy of the judicial, all those things. Many, there are several things, okay, secular nature, and there is a big list which are considered as the basic structure of the constitution. So you cannot amend that. Okay, so 2 and 3 are correct. One is wrong. There is no such thing as a basic structure is not explicitly mentioned in the Indian Constitution. Okay, we'll continue with the remaining questions in the next class.